I'd like to move on now to the waivers. It's becoming more common in the professions to have waiver clauses in your standard term contract. If you don't have a standard term contract, you need to have one, and as I said, there will be a standard precedent for you, and you can just tinker with it to suit yourselves, ideally after you've consulted an attorney. Because, you know, we all like to think that we know everything, but we don't, and I'm a great believer in specialization. But the law in South Africa is that you, I'm not talking about professional persons, that hasn't been tested yet, but suppliers of services, and significantly hospitals, can and do contract out of liability for negligence. And you will not get beyond the threshold of any private hospital group as a patient unless you sign the admission form, and tucked away in legalese is a complete waiver of liability with regard to any acts or omissions on the part of any staff in that facility or any defect in any equipment in that facility. Which is quite scary because, you know, if you think about it, you know, what are you paying for when you are admitted as a patient, very often in pain? You know, you don't have much choice. You're on the stretcher. They sign now, or your parents or your spouse signs for you, and they get away with murder, literally, because there's a waiver clause, which forces guys like me to say, well, to my client, well, we need to know the doctor because the hospital signed a waiver clause. Now, which is unfortunate, but, you know, patients suffered grievously, and you have to find a pocket that will pay. In South Africa, it's not yet been tested whether ethically professional persons such as doctors and lawyers can contract out of negligence. In the United States and Australia, you can, subject to certain limitations. So, for example, in Australia, as a lawyer, you can contract out of liability for professional negligence up to the limit of disclosed professional indemnity insurance. And I think it's probably going to hold water elsewhere in the world. So, something to think about, that you might want to include in your standard contract, or ask your attorney that does that contract for you, that he or she should include in such contract that the patient waives any professional negligence claim against you, or the patient understands and agrees that the limits of any damages arising out of alleged professional negligence will be limited to the amount of professional indemnity insurance you carry, which is currently X. And the accountants have used that with great success in the United States, UK, where they say any claim for damages will be limited to, for example, double the fee or treble the fee charged for the particular project. And I'm of the view that what I've just proposed by way of a clause for professional persons would probably be upheld by South African courts. Because if there's proper disclosure, number one. Number two, if there is a level of cover, so the patient is not left bereft of any remedy, a court may well hold that it's fair. There's fairness both ways, because let's face it, how many claims do you need before you're blown out financially? And PI insurance is expensive for us as well.